Today we're going to talk about accrual clauses in contracts. That is, provisions in contracts that have to do with when the applicable statute of limitations begins to run for claims for breach of the contract. This is an often overlooked but very important part of a contract for virtually any project. Before we talk about the contract clauses themselves, let's talk a little bit about statutes of limitations, what they are, how they work, that kind of thing. Most people have a basic understanding of what is a statute of limitations, and at its simplest, what it is a certain time period that's provided by law for the bringing the filing of claims pursuant to that contract. They're called statutes of limitations because they are governed by statute. That is, they are actually laws passed by legislatures in the various states. And that means also that they can vary from state to state. In Illinois, we'll just use Illinois as an example, the statute of limitations that applies to claims for errors, virtually any kind of error in design or construction of any kind, is 4 years. So anybody bringing a claim accusing another party of having committed an error in construction or design for any kind of project has 4 years within which to bring that claim. That sounds very simple, and in concept it is. The real question usually boils down to, however, something much more complicated, which is when do you start to run that 4-year period? Now, the answer usually is, again, depending on what state you're in, the answer is governed by what's known as the discovery rule. And that means that the statute of limitations period, again in Illinois 4 years, begins to run from the time that a party knew or reasonably should have known that that party has suffered damages as a result of a problem with design or construction. Another time period that plays into this then is obviously how long does the complaining party have to actually discover the problem. That's governed by another statute known as the statute of repose. Statutes of repose are often confused with statutes of limitations, but they are in fact different. And again, to use Illinois as an example, the statute of repose period is 10 years. What that means is that a party has 10 years within which to discover a problem with the design or construction after the design or construction was provided, and then provided they discover that within the 10 years, they would then have 4 years after the date of discovery within which to file suit. So 10-year statute of repose within which to discover, and then once the discovery is made, the 4-year statute of limitations kicks in. So basic math tells us that there is the potential for exposure to claims for up to 14 years after a project is completed, assuming the error took place at or about the end of the project. The complaining party would have 10 years thereafter to discover. If you assume they discover it at the end of that 10-year period, they still have another 4 years beyond that within which to actually file a suit and not have it be deemed late. That's a long period of exposure, potentially, obviously. But even more important probably is this discovery rule business, because the standard knew or reasonably should have known is not exactly a bright line, and there's a lot of uncertainty built into that standard, which means that there can be a lot of dispute, a lot of fighting, a lot of litigation over exactly when a party knew or reasonably should have known of the injury. Now, if there's smoking gun evidence that in fact they knew, an email, a writing of some sort where they're complaining about the problem, that's the easy case. That's also very uncommon. Usually the fighting centers around the issue of reasonably should have known. When should a party reasonably have known that they had injury? That's a difficult standard to apply, and it can raise some thorny factual questions. What that also means is that in the absence of real significant evidence establishing this, that even a party that has a good, viable statute of limitations defense will be forced to litigate a case all the way through trial and at trial take up this question of when the complaining party reasonably should have known of the problem, and submit that question to a judge or to a jury to decide when it should have been known. If it should have been known prior in such a fashion that the time period has expired, that party will prevail, the defending party will prevail on statute of limitations. But if it's deemed that the complaining party could not have reasonably known in such a fashion that they could have brought the suit within that 4-year time period, it will not be deemed time barred. In short, the discovery rule, by its very nature, incorporates a lot of uncertainty on both sides to the contract in knowing exactly how long the exposure period applies for. Now, the good news is that parties are free to address this uncertainty and provide for their own time periods in their contracts, essentially like a private statute of limitations. The AIA form contracts actually do this. However, they have varied up the way they've done that over the years. And in fact, they've changed drastically their approach on this issue. Let's look at the old version first. As of the 1997 forms, for example, B141, 1997, section 1.3.7.3, provided as follows. Causes of action between the parties to this agreement pertaining to acts or failures to act shall be deemed to have accrued, and the applicable statutes of limitations shall commence to run not later than either the date of substantial completion for acts or failures to act occurring prior to substantial completion, or the date of issuance of the final certificate for payment for acts or failures to act occurring after substantial completion. In no event shall such statutes of limitations commence to run any later than the date when the architect's services are substantially completed. So, under that clause, under the 1997 forms, for the vast majority of claims, the statute of limitations begins to run at substantial completion. So in Illinois, at substantial completion, starting at that point, whatever date that is, 4 years thereafter, 4 years after the birth date of the date of substantial completion, if you will, causes of action are going to be deemed untimely. It's a very certain standard. There's no confusion about knew or reasonably should have known about claims. In fact, the point of that clause was to do away with the discovery rule, do away with all that uncertainty. Regardless of whether the complaining party knew or reasonably should have known or even could have known of a problem, within that 4-year period, if they don't file suit, they're going to lose their right to do so. Now, this provision was somewhat controversial and was challenged in various courts across the country. It was taken up in jurisdictions including California, Kansas, Kentucky, Maryland, Pennsylvania, New Jersey, New York. Illinois was a little late to the game. It didn't take this up, at least by way of a published appellate court opinion, until 2009. But, nevertheless, every one of those jurisdictions that took up this issue of the enforceability of that clause deemed it enforceable and treated it as a waiver of the discovery rule. Important side note, a case came down in Oregon last year which emphasized the importance of issuing an actual certificate of substantial completion. Long story short, there was a lack of evidence that the architect had issued a certificate, and the court, reading the accrual clause and where it talks about substantial completion is a defined term under the AIA contract. That definition is tied to the actual issuance of a certificate of substantial completion. And so the party defending that case on statute of limitations grounds did not prevail on statute of limitations grounds on the basis that in the absence of a certificate, an actual certificate of substantial completion, they could not rely upon that clause. So, bottom line, important to issue certificates of substantial completion, important to obtain certificates of substantial completion for any party that would be looking to enforce that accrual clause. Now, that was the 1997 forms. As of 2007, big change when it comes to this provision. And AIA was very explicit in reciting the reason for the change. It was indicated that the AIA Documents Committee was primarily responding to complaints from owner groups that the B-141-1997 and the B-151-1997 caused the statute of limitations to run too quickly. So owner groups were dissatisfied. They complained to AIA. AIA took this up and changed this clause as of the 2007 forms. Let's look at B-101-2007, Section 8.1.1. Here's how this clause reads now. The owner and architect shall commence all claims and causes of action, whether in contract, tort, or otherwise, against the other, arising out of or related to this agreement, in accordance with the requirements of the method of binding dispute resolution selected in this agreement, within the period specified by applicable law, but in any case not more than 10 years after the date of substantial completion of the work. The owner and architect waive all claims and causes of action not commenced in accordance with this section. So, what does that mean? Well, in my opinion, most importantly, what it means is that the discovery rule is back. That standard about knew or reasonably should have known is going to apply again. And the applicable statute of limitations in Illinois 4 years will not begin to run until the complaining party knows or reasonably should know that it has suffered injury. Once that date kicks in, they knew or reasonably should know, that's when the 4 years starts clicking off. Now, there is an outside limitation built in, which is this 10 years post-substantial completion. So this does provide an outside limitation, and it could provide for a shorter statute of limitations than would otherwise be provided under the statute, but you're still dealing with all the uncertainty that formerly had been done away with under the 1997 forms by waiving the discovery rule. Bottom line, when it comes to this change to the 2007 forms, is that they are providing for more exposure, potentially vastly more exposure, than did the former forms, which strictly cut off exposure 4 years post-substantial completion. And even worse, what they're doing is adding all of this uncertainty. So both sides to the contract now will be dealing with the discovery rule again, and could end up fighting about when the party that ultimately brings a claim, knew or reasonably should have known. That was not a consideration under the 1997 forms. It's now a consideration again pursuant to the 2007 forms. So, assuming that a party wishes to have the certainty of the, for example, 1997 forms, what's that party to do? There are several options here. The most obvious one would be to simply use the old forms. You will not get the benefit of the most current version, obviously, but that clause at least would be consistent with the law as established by these various jurisdictions, enforcing it strictly, and provide that limitation as well as that certainty, but that limitation of exposure without having to deal with the problems inherent to the discovery rule. Another option would be to use the current forms, the 2007 forms, but change that clause, actually call out a change in the document to make it more in keeping with the 1997 forms. By the way, the 1997 forms were retired by AIA as of 2009, so actually using those old forms could be easier said than done at this point. Third option would be to use a different form. ALA, the Association of Licensed Architects, has forms, and those forms include accrual clauses consistent with what was in the old 1997 AIA forms. In fact, they're probably even simpler and more straightforward in application. If we look at OA3 2014, Section 15, that section runs all of 2 sentences. And what it says is that the statute of limitations period shall commence to run on the date of substantial completion of the project. In no case shall the statute of limitations period commence to run later than the date when the architect's services are substantially completed. Simple, straightforward, no ambiguity. Statute of limitations begins to run at substantial completion and runs out 4 years thereafter, assuming you're in Illinois. So, in summary, accrual clauses in contracts are an important part of a design and construction contract. The Parties should be thinking about up front for how long claims can be brought, for how long the contracting parties will potentially be exposed to claims, be on the hook for damages. Statute of limitations exist for a reason. One of the key reasons is that parties are not exposed indefinitely to liability. Statute of limitations should also be a part, if necessary, of the negotiating process leading up to a deal to provide services on a project.